So good afternoon, everybody. We're going to get started. Some other folks we imagine will be kind of rolling in as we go. So first and foremost, thank you for making time out of your day today. Picked a good day to do this. No Brewer game at home. Jonas is resting for round two, so all good. My name is Mark Kornfeld. I am a partner in the Tampa office of Quarles Brady. I am the co-chair of the Securities and Regulatory Enforcement practice here. As many of you know, Quarles is a full-service firm, offices around the country. We were recently fortunate enough to celebrate our 125th anniversary and are in year 126. I, as part of my practice, prior to Quarles, spent nearly a decade immersed in the Madoff Recovery Initiative. Kind of part of the genesis for this is to share some of the lessons that we learned with folks to whom it might have an impact in today's economy and in today's marketplace. I was also, depending on one's viewpoint, one of the highlights or lowlights of my career was that I actually interviewed Mr. Madoff in prison for about 16 hours over 4 days. I'm happy to share some of that stuff. Some of it is governed by attorney-client privilege and work product, but I'll navigate some of that as part of the Q&A. Quite an unbelievable experience being so close to a true sociopath. So we can talk a little bit about that. Our colleague, John Hackbarth, and my co-chair of the securities practice group is under the weather and taking the L today, having acquired the flu during Easter weekend with his kids. So Matt and I will do some double duty and pick up part of the presentation. Jonathan is a securities and regulatory enforcement lawyer who services financial institutions, advisors, broker-dealers, all across the country, both in state, federal court, as well as arbitrations, and has done battle with the regulators on countless occasions. He and I work together on any number of class action and FINRA and SEC enforcements. And so with that, I'll let Matt introduce himself.
I'm Matt Splitek. I'm a commercial litigation partner in the Madison office of Quarles. In my practice, handle a lot of securities fraud class actions, as well as non-class action securities fraud cases. Outside of the securities fraud casework, also do a great deal of work on a variety of internal corporate disputes, corporate governance, corporate control, shareholder rights disputes, and derivative litigation. A number of my cases have involved companies that were dissolved or liquidated or both, and in those cases I have been on both sides of fraudulent transfer claims, which are, as you'll hear, very common in Ponzi scheme cases as well, and I've had the either good or bad fortune to be involved in two different Ponzi scheme litigations as well over the course of my work.
So before we get into the presentation, two kind of housekeeping items. First, I have to do kind of a little disclaimer. It's like the lawyerly part of the presentation. Anything I say today in terms of observations or comments or opinions are mine. I don't speak for Irving Picard or the trustee in Madoff, although I previously represented him. Those cases and that litigation is ongoing. There is a lot of activity as the trustee seeks to recover another $5 billion on behalf of victims. So my observations here today are my own and don't belong to my prior firm or to Irving and should not be attributed to him. Second is this is intended to be interactive and dynamic. Please interrupt, ask questions, shout out, follow the instructions from the nice IT guy beforehand about the microphone if you're so inclined. It'll be super cool if it's conversational and interactive and dynamic. It's absolutely not intended to be lecture-y. It'll be a lot more fun if people jump in with whatever's on their mind. So feel free to do that. And so with that, I will start us off. So just kind of as a general matter, everybody has a basic understanding of what a Ponzi scheme is, but kind of at its simplest, barest form. A Ponzi scheme is when someone takes money from one person and pays another person with that money and does not do what she or he says they're going to do with the money in terms of investment. In other words, it's other people's money. that gets moved around. And so in Madoff, Madoff told the world, investors in Palm Springs or Palm Beach, Florida, feeder funds, leverage providers, that he was running what we referred to as a split strike conversion strategy, which kind of reminds me of a show I watched when I was a kid called Bowling for Dollars, like just a weird name for a strategy. But in any event, the long and short of it being is that Mr. Madoff at no time was in fact trading securities. He was running a traditional old-fashioned Ponzi scheme where he paid new investors with old investor money, paid old investors, excuse me, with new investor money. And unfortunately, as is the case of all Ponzi schemes, they collapse under their own kind of weight when the money dries up. And in 07 and 08, when the subprime market collapsed, and when Lehman collapsed, and when the world was on fire and the economy was in a recession, Mr. Madoff could no longer refuel the Ponzi scheme. And as a result, in 08, he collapsed. So the question we often get is, how did we get here? How does the former head of NASDAQ run a 30-year plus Ponzi scheme? And the reality is that it's kind of incredible to say, but he did it in plain sight. It wasn't that hidden in the sense that he was operating a strategy where he did not promise kind of outsized or extraordinary returns. In fact, during great markets, his returns were subpar to some of the best hedge fund managers in the world. Where Madoff's strategy made no sense and was a huge red flag was when the market was bad. When the market was down 30, 40%, there was literally no way. It was impossible, a word we used all the time when we were doing the recovery, for Mr. Madoff to be positive in his strategy. He might have been down less than 30 or 40%, but there was no way he should have been up double digits. And what allowed him to operate was actually the presence of much larger frauds in the marketplace at various times along the continuum, some of which are up on the slide. We had the savings and loan scandal. We had Martin Frankel, who was like a mini Madoff, running a huge insurance scam against the banks. I had a piece of that in the late 90s, representing Dreyfus and Mellon. You had the Enron scandal. You had WorldCom. I represented Bernie Ebbers for about 6 seconds before he got indicted. There was lots of fraudulent activity in the marketplace, which allowed Mr. Madoff to sit kind of in plain sight running this extraordinary Ponzi scheme. Let me see if I can do this. There we go. So the big question, with the benefit of hindsight, but what was actually happening in real time, was did people want to know how Madoff was purportedly earning money? And the general theme, and the reason this is important is because that's one of the takeaways for all the folks who are here today who work in the banking industry, who work in compliance, who are in-house counsel to financial institutions, who work for broker-dealers, right, is what did people want to know in real time? And the common answer that was discovered over a decade and is still being discovered is not a whole lot. People were happy to receive their 10%, 12%, and not ask the kind of questions in a due diligence fashion that I would characterize as kind of elevated or platinum standard due diligence. That was not the mindset of the financial industry at the time, whether it was broker-dealers, whether it was investors, whether it was feeder funds, whether it was investment banks who were leveraging Madoff. There was a whole lot of looking the other way as an industry collectively. And that's a huge takeaway that kind of carries forward and is kind of a cautionary tale for some of the folks here today. During my time working on the Madoff case, we used to talk about this and whiteboard and strategize about lots of different things. This was like a first-year law school exam every day. The issues that were being confronted were, matters of first impression, really, really complicated, lots of different principles at issue. There was the cross-section of bankruptcy principles. There was lots of securities litigation overlaid despite the absence of securities trading. A lot of the legal decisions emanated from the 33 and the 34 Act and other securities laws. The level of knowledge of transferees, did they know it was a fraud? Did they know he was not trading? Were they on inquiry notice? Should they have known? These were all kind of the types of issues that were being confronted day to day and are still being confronted as a legal matter, all of which are applicable going forward to all of the folks who work in the financial marketplace and in banks and in accounting firms and in broker-dealers. These are the legal issues from a due diligence standpoint and a compliance standpoint that kind of carry forward from this Madoff Ponzi scheme. Two items are highlighted on the slide. One is Comedy of Nations, something that you don't really expect to be confronting other than a 1L civil procedure class when you're in law school, and extraterritoriality, which is, for shorthand, referred to as the Morrison concept. This issue was recently decided by the Second Circuit in favor of the trustee, overturning Judge Rakoff in the Southern District, as well as Judge Bernstein in the bankruptcy court overseeing all of the Madoff litigation. No small feat to win a Second Circuit appeal in New York that has negative implications against the financial industry. The impact of that decision is to allow the trustee the ability to sue subsequent transferees who received money around the world, meaning outside of the United States. The impact of the decision is to revive 44 cases. Oh, no, I'm sorry, it's 88 cases, totaling approximately $4.4 billion, which the trustee had been choked off from prior to the Second Circuit's decision. This is an unbelievably important decision in bankruptcy law, in SIPC receiverships, in trusteeships, and as well as just general bankruptcy principles. In addition, the other thing that I highlight, which we're going to talk about throughout the presentation, which is probably of some import to the folks in this room, is the idea of primary versus secondary liability. The reality is that when there's a major financial fraud, when there's a Ponzi scheme, right, the people to whom the plaintiff, the DOJ, the Attorney General, the SEC, the CFTC look is almost inevitably not the fraudster, right? The fraudster is either broke and or in jail. The people who get targeted are the banks and the auditors and the deep pocket financial investors and institutions and broker-dealers. And so kind of giving some of the takeaways from Madoff in terms of what banks and others should be looking for in terms of causes of action and where their exposure is and the importance of compliance is a thread that we'll kind of cover throughout the afternoon. What you'll see is lots of different types of claims. We've identified a bunch of them that are often seen in litigation against banks and other third parties, ranging from the high level of scienter, of aiding and abetting fraud, where you essentially have to demonstrate that the bank was close to in on it, as opposed to transferee litigation, where the focus on the transferee's intent is far lower, where you focus more on the fraudster's intent as to whether or not a fraud was being effectuated. In the world of Ponzi schemes and financial fraud, inevitably, as I've kind of foreshadowed, there is a blame game that takes place, and advisors, auditors, banks, and broker-dealers, as well as high net worth investors are often right in the middle of these types of engagements, whether it's on the civil side with plaintiffs who've suffered losses or on the regulatory side from the SEC or others who are seeking to hold people accountable. So that's a really, yes? I believe the Second Circuit opinion they will try to appeal, but I would suggest that it's very unlikely that the Supreme Court will take cert. There is no kind of dispute amongst the circuits on the issue. So while I believe the defendants are going to push for cert, I think it'll be denied. And with that, I'm going to kind of yield the floor to Matt. He'll give you a little bit of an overview of some of the claims and some of the defenses that we'll confront in these type of schemes.
So looking first at who it is that would be bringing third-party claims in the wake of a Ponzi scheme, the answer is there are many, many parties that could be bringing them, and that means there are many avenues for exposure for third parties. Claims can be brought by regulators. They can be brought by a bankruptcy trustee, a receiver in charge of a receivership estate, and then investors or creditors can bring the claims themselves, either in a class action or in an individual suit. And in many cases, you have multiple different proceedings going on in parallel against third parties. We've pulled out, Mark gave you the very long list of potential claims that could be brought against third parties. We've tried to pull out a couple that are the most common, just to go through those. Aiding and abetting, it's a very difficult claim to prove, but it is very commonly brought against third parties. And the reason is that the stakes are very high in an aiding and abetting claim. All the damages essentially are available. If aiding and abetting is proved, then the defendant is liable for the fraud and all the damages caused for the fraud, because the defendant is found to have helped to perpetrate the fraud. And as we'll see in another slide, not all the claims that can be brought against third parties would have all the same damages that are caused by the Ponzi scheme on the table. The elements, number one, the existence of an underlying fraud, that generally is not all that hard to prove if there's a Ponzi scheme. And there may, in fact, already be admissions or a guilty plea or what have you that can be used to prove up that element. Number two, actual knowledge of the fraudulent scheme. That tends to be the most important element of an aiding and abetting claim. And actual knowledge has to be distinguished from constructive knowledge. So there are, in other claims, constructive knowledge will suffice, and all that needs to be shown is that the defendant should have known. The defendant had enough information to put them on inquiry notice. They should have done an investigation. They should have uncovered the fraud. Here, actual knowledge is required, which is what makes this hard to prove. Although, an important thing to remember is that under agency principles, the knowledge of an employee of an entity is generally imputed to the entity itself. So if one employee of a third-party defendant, of a financial institution or another defendant had knowledge of the fraud, that can be imputed up, and it's not necessary to prove that everybody knew about it.
Yeah, echoing Matt here, we'll talk a little more about it, and we put it in the materials. Obviously, there's a recent Supreme Court case, Lorenzo, that has elasticized scheme liability, and conspiracy and scheme liability is kind of the kissing cousin to aiding and abetting fraud claims. It's made it a little bit easier to pursue those type of claims under the securities laws. Aiding and abetting is, normally prohibited under central bank in the 10b-5. These are mostly state law claims. So depending on your jurisdiction, some jurisdictions are a little bit more favorable on these claims under a more liberal kind of recklessness standard as opposed to true, actual, subjective knowledge. So one tweak to that.
And then the last element needs to be proof of substantial assistance in order to further the violation. And there have to be affirmative acts. It can't just be passive conduct, something affirmative taken to further the fraud. Fraudulent transfer claims, also very, very common in Ponzi scheme cases. There are lower damages in a fraudulent transfer claim. What's being sought is to unwind a transfer that was made to the third party, and so all that's at issue is what the third party received, and the trustee or what have you is trying to claw back. So unlike with the aiding and abetting claim, you don't have all the damages caused by the fraud on the table. A little background, there are two kinds of fraudulent transfers. There's actual fraud, and there the key is intent to defraud. Creditors must be proven, but the important thing there is that it's the intent of the debtor, of the transferor, that has to be proven. It doesn't matter if the party receiving the money has a bad intent. And in a Ponzi scheme case, of course, an intent to defraud creditors can be more easily proven than in another case, if you're just focusing on the intent of the transferor or the debtor. There's also constructive fraud. And there, the key elements are that the third party received a transfer without giving reasonably equivalent value in exchange. And then in addition to that, you need insolvency or some other kind of financial distress. You need, the debtor was in a condition where financially it shouldn't have been making this transfer to the third party that received it. In Ponzi scheme cases, there has been widespread acceptance of a number of presumptions that really eliminate the need to prove up a lot of the elements of fraudulent transfer claims. In one of them, many courts have held that if once there's a Ponzi scheme, that they will presume as a matter of law that any transfer made in furtherance of the scheme is made with fraudulent intent. And really what that means is that the court is going to presume that any transfer made in furtherance of the scheme is actually fraudulent. The claim of an actually fraudulent transfer is proven, and the burden shifts to the defendant to assert any affirmative defenses. And that obviously makes proof of that claim a great deal easier. It's just taken care of really by virtue of the presumption.
Yeah.
Matt, what does the court look to determine that you've proven there's a Ponzi?
Well, that's a good question, and there really is not a precise definition of Ponzi scheme. Skipping ahead to something I was going to add at the end here, some courts have started to push back against these presumptions. The key reason really is that there is no basis for them in the text of the Uniform Fraudulent Transfer Act that has been adopted by nearly all the states. But in addition, there is, and Mark would speak to this better than I would, but there is not an exact legal definition of Ponzi scheme.
Yeah, so in most Ponzi schemes, it's demonstrated in one of a couple of ways. One, it's through books and records. You can demonstrate by looking back, and this is what happened in Madoff, that there was in fact no trading. You can go through bank statements and false account statements and kind of tie together the lack of trading. It's kind of a weird thing because you're proving a negative, like there was no actual trading, and you have to demonstrate that. The other alternative, of course, is there's usually a guilty plea, which gets accepted. So if you read the litany of Madoff-related litigation cases, the initial paragraph in every judge's opinion says, a Ponzi scheme has been presumed here based on the guilty plea of Mr. Madoff and some of his associates at BLMIS and the lack of any trading. So it's just kind of something that gets demonstrated through the investigation. And it's often kind of taken as accepted unless there's somebody pushing back saying, no, he was really trading. So that's kind of the way it is.
Other presumptions, a debtor who runs a Ponzi scheme is presumed to be insolvent, and that goes to one of the elements of constructive fraud, insolvency or other financial distress. That's presumed to be proven. And then finally, a presumption that any value given by the recipient of the transfer is limited to the principal that was given the original investment and excludes any interest or other return that the investor was expecting. And that can be important in a Ponzi scheme case. There are investors who've been getting account statements, and they have documents purporting to show that they're entitled to X number of dollars above what they invested at the outset. And the court's approach to that is to say, that's just fictional. You put in what you put in, and the documents purporting to show that at some point you got some fabricated return back later on are just immaterial to the court because the investments never happened.
Yeah, this is super important. So in the Madoff case, this was a huge battleground between lots of different competing factions of investors. So first of all, Irving, as the trustee in Madoff, was limited and restricted solely to transferee litigation. He was not allowed by law to pursue any sort of civil causes of action. So he was deemed not to have standing to bring aiding and abetting claims or conversion claims or even unjust enrichment claims. He was limited to claims under the bankruptcy code based on state law and the Uniform Transfer Act, Fraudulent Transfer Act. So that was important. The issue of money in versus money out was a huge legal battle. A lot of people fought and litigated the issue of what about my lost opportunity, right? If Madoff was stealing the money and I didn't have the benefit of it and I thought I was making 10% on paper, right? And if I can't get that money back, I'm entitled to interest. And the court ruled against that group and in favor of the trustee, that in real life, you can't give people fake profit. You just can't. And the only way to recover money as part of the fraud was to bring the money back into the estate that was actual money in and actual money that went out. So it was basically as simple as cash in, cash out, but there was no fictional profit. There was no interest that was allowed to be calculated as part of the distributions that the trustee has made over the course of a decade. So these issues were being battled. They did go up to the Supreme Court, and so it was denied after the Second Circuit upheld the trustee's methodology for calculating some of this type of stuff. Very tense recovery action, bunch of net winners who had actually received more money than they put in, a bunch of net losers who were being sued even though they suffered losses. The biggest example of that were the feeder funds, who at the end of the day took a net loss, but they were taking out hundreds of millions of dollars along the way and then transferring that to their shareholders. So these were issues that were being fought on multiple fronts against multiple types of claimants and people that the trustee was seeking to recover money from. His job was to bring all the money he could back into the estate and then distribute it back out kind of like socially based on a pro rata equitable distribution. So these issues that Matt have outlined, these were the battleground issues in the recovery, and they still are today. Yes? It's a great question, and it's something that's often misunderstood here. This is not like a normal bankruptcy where the bankruptcy trustee or receiver might have the ability to take a share of the recovery on a contingent basis. That's not this. Irving and Baker Hostetler and all the other law firms around the world and all the consultants like FTI and Alex Partners and Duff and Phelps, they were paid by SIPC out of the industry fees that the broker-dealers pay. This was the classic rainy day fund, and that fund has been used over the last decade. Every penny that got recovered by the trustee was distributed to victims. No money from the recovery paid for legal fees. Those fees were paid outside by SIPC, who is actually, in my personal view, a co-contributor to the success of that effort, because without their funding of the litigation, it's my personal view that the trustee and folks like myself don't achieve as much success along the way. Being funded against some of the greatest law firms in the world, against some of the deepest pockets in the world, being allowed to kind of go toe-to-toe in the litigation and the investigation leveled the negotiating playing field. And I'll talk about some of the settlements that I was part of the negotiations in. But the short answer is no money comes out of the recovery. It all goes to the victims. Yes? So SIPC is not an insurer, and I have to say that 1,000 times because it was beaten into me for the years I worked there. But SIPC is basically the congressional quasi-group that oversees the broker-dealer industry. They are funded through fees that are paid for over years and years and years and years by the industry as a whole. And when the scheme hit, SIPC expedited about $800 million so that victims could get money quicker while the investigation was at its very, very early stage. So they actually advanced a significant amount of money to victims up front, but they are definitely not insurance. They are there to help kind of bridge gaps when a broker-dealer, which Madoff's company was, collapses.
Just so I'm clear, they funded the broker-dealer legal fees, not the average investor on the street.
They didn't fund the broker-dealer fees. They funded the trustee who was appointed by the court pursuant to Congress. So they paid, so Baker Hostetler was the lead firm representing Irving Picard, who was the trustee. SIPC would receive those bills almost like a client, even though Irving was the client, and they would pay those bills with a discount and a courtesy discount that was held, as well as a holdback. They weren't paying broker-dealer fees. It was the reverse. Broker-dealers pay into the fund, and that fund is used in circumstances like this. Normally, when a SIPC fund collapses, it's of a much smaller nature. That's what makes this much more historic. A lot of frauds in the broker-dealer industry are really, really small. They're much more contained. It doesn't take years to unravel. It's pretty straightforward. A couple of $1 million gets redistributed. That's not this. That's what makes this, pretty unprecedented.
As I mentioned, there have been some courts recently who have pushed back against accepting these presumptions in Ponzi scheme cases. The Supreme Court of Minnesota rejected all of them as not being grounded in the statutory text, and that had an effect on the litigation relating to the Petters Ponzi scheme, which was out of Minnesota. The Eighth Circuit Court of Appeals adopted the Supreme Court of Minnesota's construction of the Uniform Fraudulent Transfer Act and forced the trustee in the Petters Ponzi litigation to prove up all the elements of the fraudulent transfer claims without relying on any of the presumptions. It resulted in some of the claims being dismissed, and it had, in a case like Petters, it can be important to get whether the presumptions are available or not for a trustee to rely upon, because some Ponzi schemes can have legitimate components. And Petters, for example, at one point purchased Polaroid, as well as other legitimate businesses. And it was a part of the Ponzi scheme in the sense that Petters was purchasing legitimate businesses in order to provide himself with cover and legitimacy to forestall the discovery of the larger, completely illegitimate component of his business, if that's an appropriate term. But there were parties that interacted with or received transfers from businesses that were, as freestanding entities themselves, were not necessarily Ponzi schemes. And so it was damaging to the trustee in that case not to have those presumptions available.
Not the case of Madoff. No trading at all.
Yeah. Once the elements are proven, whether by presuming them proven as a matter of law or not, the defenses that are available, first, that the transferee, the defendant here, took the transfer in good faith without knowledge of the fraud and in exchange for value. This is a defense against the claim of an actually fraudulent transfer. It's also generally a defense that can be used by subsequent transferees. As Mark mentioned earlier, it's not just the first recipient of the transfer from the Ponzi scheme operator that may be targeted. The funds that are received can then be transferred to subsequent transferees, and those transferees can also be targeted by the trustee, but that defense is available to them as well. Here, although I don't know how this may have played out differently in the Madoff litigation, but as a general matter, when you're looking at the good faith of the recipient of the transferee, it's an objective standard. We're not looking for actual subjective knowledge. It is about whether the recipient had inquiry notice, knew about enough information that should have put them on notice, caused them to investigate and discover the fraud, although that may have gone a little sideways in the Madoff cases.
So I'll interject here. And so earlier I told you that the trustees scored a huge win at the Second Circuit in being allowed now to pursue subsequent transferees around the world. That's the good news. The bad news is that the majority, from the trustees' perspective, is that the majority, if not all of those cases, I would expect will be dismissed at the motion to dismiss stage, because the current law that has emerged in the Madoff Ponzi scheme is that the subsequent transferees are no longer being required to assert good faith as an affirmative defense, but rather the trustee is being required to plead bad faith subjectively, which is a huge departure from the historic kind of doctrine in New York especially, but in bankruptcy courts around the world, which normally applied an inquiry notice, knew or should have known, objective, reasonable person standard. The trustee is now being required to demonstrate that entities who invested in feeder funds in the BVI or in the Caymans or in Luxembourg or in other parts of the world had some sort of subjective knowledge that they were investing into a scheme. That's an unbelievably high standard that the trustee is going to be held to on these amended complaints that he's going to be filing in light of the Second Circuit opinion. That issue is absolutely going to get to the Second Circuit because there is a litany of counter law to that effect. And a SIPC engagement is being treated differently than a normal bankruptcy. And so that issue is kind of the next big thing that's looming at the Second Circuit level. And that's why this case is taking a really long time. And I'll talk a little bit about why they're in year 11. It's a titanic legal fight. So we'll talk a little bit more about that. But Matt's quite right. The Madoff case is now an outlier to the normal approach to subsequent transferee decisions.
Other defenses, that the recipient was a mere conduit, really didn't receive the transfer, never had any control of it. It was just passing through on the way to the actual transferee. And then the in pari delicto defense. And the essential idea there is when you've got two wrongdoers who are fighting it out in court, that the court is not going to grant any relief between them. And if one wrongdoer has a claim or a defense against the other, it's not an issue for the court to decide. They're both in the wrong, and there's no need for judicial intervention. This defense is frequently asserted in Ponzi scheme cases, and the key here is that the trustee is standing in the shoes of the debtor if trustee is bringing claims against third parties. And so the trustee is not a wrongdoer by any means, but the debtor, whose shoes the trustee is standing in a Ponzi scheme case, is a wrongdoer in some fashion. And so if the defendant can prove that the debtor is a wrongdoer, this defense may be viable. You get back again to questions of imputed knowledge, and those can get complicated as well. Just under general agency principles, the knowledge of the employees of the debtor would be imputed to the debtor itself, and the wrongful acts of the employees can be imputed to the debtor then. But then there's a doctrine called the adverse interest doctrine, and under that, and it varies from jurisdiction to jurisdiction how it's phrased exactly, but the gist of it is if you have a bad actor who is acting in his or her own interest, adversely to the interest of the debtor, of the entity that's employing that person, then that bad actor's knowledge and intent may not be imputed to the debtor because they're not actually acting on the debtor's behalf. They're acting adversely to the debtor. And yet there's also an exception to the exception, which is if the bad actor has complete control of the debtor, then the adverse interest doctrine may not apply, and you get right back to the debtor being a wrongdoer again.
Yeah, and so in pari was an early issue in the Madoff case. Look, we came at the board when we were trying to figure out the Ponzi scheme and how to recover money with a pretty broad perspective, saying that this was a historic Ponzi scheme, and if there was ever a case to kind of push the legal envelope, this was the one. You know, I've spent a career representing banks and working on the defense side of cases and kind of had a pretty good sense as to how aggressive the defense was going to be to lots of different claims. And on behalf of the victims of Madoff, there was a philosophy that we were going to test the boundaries. And, you know, one of the arguments that got made to the circuit was, how can the equitable doctrine of in pari delicto choke off the trustee who's been appointed by Congress to help victims recover money? When did Irving Bicard become Bernie Madoff? That doesn't make any sense when you say it out loud. And yet, notwithstanding the simplicity of my eloquence, that argument was wholly rejected, and in pari delicto was absolutely firmly entrenched as the law of the land. If you step into the shoes of the debtor, you are the debtor. You do not have independent standing, and we as a court are not going to do equity when you are representing a wrongdoer. And so the trustee was restricted to transferee litigation only, as opposed to civil RICO, aiding and abetting, and lots of other juicy types of common law claims. So one would think that after Madoff, all the Ponzi schemes in the world would stop and financial fraud would come to a conclusion. That would be quite incorrect. We put up a few here. If you really want to catch a cool summary of the world since Madoff, our colleague in Tampa, Jordan Maglich, he runs probably the preeminent financial blog called Ponzi Tracker. And he yesterday posted a significant article that gives you a database of fraud since Madoff. It's really cool. Just came out yesterday. It's definitely worth a look if this is an area that interests you. For people who work for banks and for compliance and for, you know, financial institutions, it's definitely a good read. Jordan worked on the Nadal recovery effort, hundreds of millions of dollars out of Florida. The $1 billion whale is probably the most timely non-Ponzi scheme up there. It's not a Ponzi scheme, but it was a worldwide financial fraud. It emanates out of the country of Malaysia. The $1 billion whale is one of the greatest books I've ever read, and I hate reading. So, like, this is a book I highly recommend. It's super timely. The former prime minister of Malaysia is currently on trial, arising out of that. And while you all were making your way over here today, the Department of Justice and the U.S. Attorney's Office announced that they're going to seek criminal penalties against Goldman Sachs, which should send shudders down everybody's spine who is in the financial world and in the banking world, because you know, the lesson of the 2008 collapse was, you know, the idea that there is no bank that could fail that's that big. Well, you know, be careful. I mean, it's 10 years later, and now Goldman Sachs is being sought after for criminal penalties arising out of a financial fraud that they got ensnared in not long after they settled for $500 million in the mortgage crisis. So this stuff that we're talking about, it's super timely. The impact of Madoff is felt on a daily basis, both on the regulatory side as well as on the litigation side. And those of us who practice in this space, we pay attention to this kind of stuff. You know, there's lots of different frauds. We've given you kind of like a, you know, super short sampling here. Even here in the great state of Wisconsin, about a month ago, a gentleman by the name of O'Connor pled guilty to a Ponzi scheme, much smaller in nature. It's about $12.5 billion. For the basketball fans in the audience, you know, in 2016, Tate George, kind of a famous one shining moment NCAA guy, he got ensnared and went to jail for a Ponzi scheme here in Wisconsin. the one thing that's become super clear is that Ponzi schemes are not geographically specific. They're not perpetrator specific. There is no rhyme or reason to where, how, and who conducts Ponzi schemes. What we saw in the early stages of Madoff is that it started as what we refer to as an affinity fraud. It was targeting wealthy Jewish community members in South Florida. In the early 90s, the fraud expanded dramatically across the globe with the introduction of new fuel from feeder funds that were set up abroad. Feeder funds were exactly what their name implies. They got money from investors and fed it to Madoff. A lot of the feeder funds were kind of capturing Madoff's money in the sense they were earning the 2% of assets under management and the 20% in profits that really should have gone to Madoff if he was actually running a true investment strategy. They were feeding him the money. He was paying them back in kind with hundreds of millions in fees. And that perpetuated the fraud for almost 2 additional decades. In recent days, you see a lot of fraud, especially in my neck of the woods, targeted at the elderly. There's a bunch of religious-based frauds. One is most recently is the money doctor, targeting Christian retirees. We see a lot of these type of frauds in the last decade post-Madoff. We then, of course, have what we just referred to, and here's a plug for Jordan's website on Ponzi Tracker. We see some really nutty Ponzi schemes. One is what we affectionately refer to as the goat-raising Ponzi scheme, where people were actually investing in, some sort of scheme involving the raising of goats. So sometimes the underlying product that the manager, quote unquote, is investing in is itself a little bit of a red flag. But it cuts across lots of stuff. There was a Ponzi scheme involving Hamilton tickets in New York. I had a bunch of friends who got caught up in that. So yeah, it's pretty wild, the type of schemes that are still out there. The Madoff recovery is pretty historic in the sense of its scope and geography and duration. Nothing like it exists in the marketplace. It was $18 billion in lost principal, and it was $65 billion in phony profits in manufactured account statements. There are lots of other Ponzi schemes that are super small. There's lots of Ponzi schemes in the billions of dollars, but none have kind of reached the heights of Madoff in terms of length. The Ponzi scheme dates back to the 70s and really kind of hits its stride in the mid-90s when the foreign money kind of comes into the game. One kind of interesting, yes?
How's that Madoff $12 billion recovered compared to the total loss?
So to date, it's about 18 billion is the total loss, and it's in excess of 12 billion. So they're almost at 70 cents on the dollar in terms of recovery. Also super important, folks who invested about $1.5 million, $1.6 million or less have been made completely whole by virtue of the recovery plus the early advances that SIPC afforded some of the victims. So there's been a pretty extraordinary success rate that has been achieved there, both historically and just in kind of real dollars and cents in terms of what people got back so far. And they're not done. Obviously, they're still pursuing. The last $5 billion is always the hardest, is what we used to say. There's a lot more. Yes?
Going back to the issue of value, if somebody put in like 10 million and then they feed back 12 million, 2 million gets clawed back.
Yeah, that would be in the what I'll call the left side of the house, the net winner category. The trustee, whether or not that person, and quite often that person was what we would call a good faith person or an innocent person, might have been someone who invested in the 80s, right? And, but at the end of the day, that person is in possession of Matt's money. And so clawing back the fake profits is simply what's required as a fiduciary there. You don't get to keep stolen money. So yes, there would be a lot of clawback actions, although certain people, of course, the trustee was unbelievably equitable here, and Irving was extraordinarily judicious in this process in terms of creating hardship applications, allowing people to make a case why they didn't have the money, They were elderly, they were infirm, the money had been spent because they didn't realize it was stolen. They processed over 16,000 claims and thousands of hardship applications, one at a time, many of which were granted for lots of equitable reasons. Yes?
Is the trustee to track how many people landed with them? Use $10 million.
Tremendous question. And there were, yeah, the short answer is yes, but there were very few. But there was one major feeder fund who was afraid of being tagged by the trustee and chose not to enter the U.S. jurisdiction or appear in any way, including by filing a claim that they were entitled to money, and that was almost $1 billion, that particular fund. They were very reticent to be participating in the fund recovery effort, and it's super important because at the initial stages of this, right, the betting money was that the recovery in Madoff was going to be pennies on the dollar, and that was the bet that that fund placed. Had they known that the trustee was going to get above 70 cents, they would have filed a claim even though they would have been a target because they would have been able to negotiate getting money back. And the kind of as a side anecdote, people who practice in the bankruptcy field are familiar with claims traders who kind of trade on bankruptcy-related claims and infuse capital to victims who are on the short end of the bankruptcy. In this particular case, the claims trading was at a much higher level in terms of some of the names that were investing in our attempt to achieve success. And so, very early on, a gentleman by the name of Jeffrey Pickauer reached a settlement. His estate did. He had passed away. He'd had a heart attack. His widow reached a historic settlement with the Department of Justice and with the trustee for over $5 billion. And the minute the ink was dry on that settlement, the claims market went from about 32 cents in trading to about 68 cents in trading. So for us who were working on the case, it was kind of this really fascinating way to validate how you were doing. Like people were betting on how your success would be. It became like a sub-asset class. And a lot of the claims today have already been traded. So the recovery now is not necessarily going to a individual person who might have lost her or his retirement fund. It's going to institutions who were kind of arbitraging or leveraging this type of recovery effort. Say it one more time. I'm having trouble hearing you. Maybe hit the mic. Oh, okay. Sorry.
How could they run the fraud for years without somehow being tangled up with the IRS? There's all the investors filing statements and them and so on and so forth.
So it's a great question. And so there was, of course, an IRS element of the Madoff recovery, which included a settlement with the IRS for $200 million, which my friend and partner Betsy back in New York when I was at Baker negotiated directly with the IRS. The short answer is that Madoff was returning people's money, right? That's one of the reasons the fraud lived as long as it did, is that he gave liquidity. So if someone wanted their money back, he gave it to them with some profit. He was giving them interest, and it was treated as though he had actually made the money, and people file tax returns, kind of as though he literally invested the money. So the IRS had no real reason to suspect anything because returns were being filed in the normal course and kind of looked the way they should in terms of the marketplace. Sorry, did you have a question? Okay. So in any event, there's one kind of weird side note. If you look at the bottom here, there's the Stanford Ponzi scheme, and to date, about 10% of that victim class has received, about 10% recovery. Part of the reason is that Stanford was not funded by SIPC because it didn't fall within the statutory requirements for SIPC to advance funds. What makes that really interesting is that it's the first time in recent history that the SEC litigated with SIPC directly about whether SIPC was supposed to fund that recovery, and SIPC was on the right side of the law there, and the court found that they were not supposed to legally fund that recovery, and it's had a really adverse effect on the trustee in Stanford, so just kind of as a point of information. Yeah, please. Yeah, so SIPC, as I think I mentioned earlier, but I might have been unclear, is that they advanced under their statutory provisions, they advanced kind of $500,000, which is the maximum allowed on a customer by customer basis, and in the aggregate, they advanced almost $800 million super early after the fraud was revealed globally to the world at large. And so they followed kind of their statutory mandate, but they also did it in a way that they weren't required to do up front. They didn't have to advance that money on the expedited basis that they did. They did it, for equitable and humane reasons. They wanted to get people some money really, really quickly because a lot of people just got absolutely totaled and lost their life savings and stuff like that. As I mentioned earlier, Jordan has a really cool database on the recent Ponzi activity. We've seen a lot of Ponzi activity in the last 10 years, but the revelation of Ponzi schemes are down. Doesn't mean Ponzi schemes aren't occurring right now. It just means they're not being revealed, which is often the case when you have a huge run in a good market. Good markets are the best friend of fraudsters. They mask fraud all the time, and that's probably what's happening based on kind of the historical trends. And so with that, I'm going to yield the floor back to Matt to give you a little bit about the change in climate in the SEC. I'm sorry, you had a question? Domestic, although there's a bunch of foreign stuff in there too, but principally domestic.
So, as you might imagine, there's been a shift in the SEC's approach since Trump took over. Mary Jo White, who was the chairwoman when Obama was president, she pushed a quote-unquote broken windows approach, a nod to William Bratton and the police strategy in New York City. The focus was on addressing even very minor issues and in a high volume of cases. The SEC brought they focused on a large number of reporting issues, even just missed deadlines during Mary Jo White's tenure. And in 2015 and 2016, the overall volume of cases was extremely high. The new chairman, Jay Clayton, with support as well from Commissioner Pierce, who's another Trump appointee, has changed the focus to emphasize quality over quantity and having a very explicit focus on protecting seniors, Main Street investors, the retail side, a focus on fraud. There's been a downtick in financial reporting cases. There's been an uptick in cases relating to financial fraud, Ponzi schemes. And the way that when you look at the overall numbers between 15 and 16 and then to 17 and 18, there was a noticeable downturn that began in 17 after Trump took office. That continued through the first half of 2018. Interestingly, it did in the second half of 2018, even despite there being staffing issues at the end of the year with the shutdown. There was a huge surge in SEC actions in the second half of 2018, and the overall numbers are up again, not at the level that they were in 15 and 16, but they are trending upwards, notwithstanding there still being a focus again on larger, more important cases that are important to retail or Main Street investors.
And in kind of looking at the landscape here, looking at the differences in bios of the respective chairs, Mary Jo White is, first-class enforcement litigator. That's her background. Chairman Clayton comes from the finance side, much more focused on capital raising, and especially in good markets, wants to focus on IPOs and, encouraging liquidity and lending and leverage. So it's just, different backgrounds who are kind of the chair or the point person at the SEC, and that philosophy is pretty evident in the way they've gone about enforcement as a general matter.
The packets that we had there by the door, we have some of our publications, including from John Hackbarth, our absent colleague here today, relating to some of the recent important cases relating to the SEC. But wanted to go through the main points on those as well. The first one, Lorenzo versus SEC. And this is an extremely important case. The background here is there was an investment banker at a brokerage firm. He sent an email out to potential investors with some text in there about the financial standing of a startup. The paragraphs were just copied and pasted from something drafted by a superior. But he sent it out. He was the point of contact for the potential investors. There was a Rule 10b-5 action against the person who sent the email. In most Rule 10b-5 cases, the part of the rule that's at issue is the part that prohibits the making of untrue statements of material fact. That is generally what we find ourselves litigating in those cases. This investment banker did not make an untrue statement of material fact under some other recent Supreme Court case law. He wasn't the maker of the statement because he didn't have ultimate authority over it. However, Rule 10b-5 has other provisions that really have not been litigated nearly as much over the years, generally referred to as the scheme liability provisions. And in Lorenzo, the Supreme Court held that this investment banker could be held liable, in theory, under the scheme liability provisions, even though he wasn't the maker of the statement. He had disseminated the statement, and assuming that it was part of a fraudulent scheme, and importantly, that the investment banker would have knowledge that the statements were false and knowledge of the fraud, that he could still be liable. This we haven't seen yet how much this will play out, but the likelihood is this is going to result in more scheme liability cases and private causes of action. Not this was an SEC case, but investors can bring private causes of action as well under 10b-5, and I think the anticipation there is that there's going to be, we who litigate these cases are going to be dealing with a lot more scheme liability litigation than we have in the past.
Yeah, Matt's spot on. I've been social media blasting about this. This is going to be a significant battleground for the folks in this room whose clients are often the subject of these type of cases. On the defense side, there's going to be, a renewed vigor from the class action plaintiff bar to adopt and use Lorenzo as a roadmap to surviving motions to dismiss that in prior lives probably would have been granted. So there is going to be a lot more creative scheme liability type cases going forward.
Kokesh v. SEC. Here, this one turned out not well for the SEC. The background here, the SEC has statutory authority to seek civil penalties, but there's a 5-year statute of limitations applying to claims for those penalties. Since the 70s, the SEC has also been granted authority by the courts to seek disgorgement as a remedy. And there's no statute of limitations that, or historically at least, there was no statute of limitations that applied to that. The remedy was developed through the case law. the SEC's ability to seek disgorgement with no time limits was extremely important. In 2016, I think the total disgorgement collections were double the civil penalties that the SEC got. In 2017, it was more than triple. This gave defendants a massive incentive to settle if the size of the claim was inflated due to the SEC's ability to seek disgorgement going back, however, 10, 20 years, who knows. In Kokesh, the Supreme Court put the clamp on that and said disgorgement is a penalty. It is subject to the same 5-year statute of limitations that claims for civil penalties are. And then in addition, there is a footnote in Kokesh raising the question whether the SEC can seek disgorgement at all under the statute. We will see how that
Good day for the defense bar.
Yes, we will see how that plays out. That will certainly be litigated, and that question will be answered eventually. There's a bill that's, I think, it's just a month old at this point. Senator Warner and Senator Kennedy have brought it, that would extend the statute of limitations from 5 years to 10 years. We'll see where that goes, but this could be, at least the statute of limitations issue could be addressed by Congress. But another one where we are waiting to see what the fallout from that one is. And then I'm going to skip digital realty because I think Mark's going to talk about that a bit. But Lucia v. SEC, the SEC has administrative law judges, I think 5 of them. The administrative law judges functionally really have all the powers of Article III trial judges. For years, the ALJs were not appointed by the commissioners, by the SEC, the commission itself. Rather, that was delegated to the staff. In Lucia, Supreme Court held that's unconstitutional. The ALJs need to be appointed by the commission. In that case, a rehearing was ordered because the defendant had not gotten a hearing by a properly constitutionally appointed ALJ, and so the case has to be completely reheard by a new ALJ, not the one who heard it the first time. The SEC responded by ratifying the appointments of all the ALJs. It hasn't been determined yet whether that's going to work, simply ratifying the appointments of the administrative law judges who were improperly appointed in the first place. And then on top of that, there's a fair amount of uncertainty here about all the other hearings that were conducted by the ALGs before their appointments were ratified, how many of those cases are going to be reheard or not, as has to happen in Lucia.
So kind of just echoing a little bit of what Matt just said is that the Lucia opinion is super important because for a very long time, the perception of defendants, clients who I've represented, and some of the folks who might be defendants one day who were sitting in the room, was that the SEC was kind of, stacking the deck by bringing administrative law cases where they were appointing the judges, as opposed to cases in front of federal district court judges. I wrote a bunch about this, about the SEC's home court advantage. They had a greater success rate by a pretty significant multiple when they would bring cases before an ALJ, as opposed to, a district court judge. And so the Lucia opinion casts some doubt about all that, creates some uncertainty, both from a regulatory standpoint, politically, optically. So how that plays out in the future in terms of the SEC's success rate on cases and how it drives or doesn't drive settlements, it's no small matter that's kind of emerging here. It's also all a byproduct of kind of the SEC post-Madoff, in light of the fact, and I'll talk a little bit about this, that the SEC took a pretty big public flogging as a result of Madoff, and did it, their own kind of introspective, self-diagnostic. They came out with a, nearly 500-page OIG report post-Madoff to kind of second-guess themselves on where they might have gone wrong. My personal view is that the SEC, of course, is an easy target in Madoff because they're the regulators charged with kind of making sure that frauds like this don't happen on their watch. But I think it's unfair to kind of cast them as the sole group that kind of missed the boat here. I think the financial industry as a whole bears a lot of collective responsibility for what went on in Madoff. There was a lot of looking of the other way because people just wanted the 10% every month. They didn't really care how he was getting there. Like, they knew it didn't seem right. Like, how could he be making money in bad markets? Oh, yeah, I don't need to know. I'll just kind of take my 10% and, kind of be happy with it. So people were pretty comfortable. And that cut across lots of different institutions. It cut across the accounting industry, it cut across the broker-dealer industry, the investment community, the folks who were putting pension money in there. There was a lot of, I don't want to know, that really can't all be laid at the feet of the SEC, in my personal view. So we now turn to kind of like, oh yeah, sir. Yeah. Yeah. So it's yeah, and in fact, I mean, that's a great point, and that's another reason why I also tag the industry, because the theoretical volume that Madoff was doing in, options trading abroad was like 9 gazillion times the actual volume that anyone would do in a day. So if you were looking, right, it was easy to spot, right? And the SEC, look, in fairness, in the 90s and the early 2000s, the SEC staff was often young lawyers right out of law school. The broker-dealer industry was 12,000 strong. Trying to examine all of them at like a suspecting fraud level is hindsight, if we're being objective. And again, Madoff came to the table with a pedigree, right? He was the former head of NASDAQ. He was running, at least for a while, a legitimate market-making business. Stopped being profitable, in the late 90s, early 2000s, when the world went to decimalization. Their spreads went terrible. There should have been a way to kind of see it. But, I think there is a little bit of hindsight's 2020. They had opportunities, for sure, along the way. They had a big opportunity in 92. They had another opportunity in 01. They had them kind of dead to rights. If you've seen the movies that were done about Madoff, that moment in 2005 where Madoff thought the jig was up, right, because all they had to do was call, DCC, right, that was legitimate. If they had just called up the phone and said, here's the guy's number, can you confirm the trades, he would have been exposed. And they didn't do that. So they missed an opportunity for sure. But I'm, still pretty reticent to kind of lay it all at the feet of the SEC. I think that other people, and look, I think the industry is required to police itself. I think it's, the banks that get tagged with big settlements, which we see all the time. I mean, compliance is not something that's supposed to be done after there's an oil spill. It's supposed to be done before an oil spill to prevent it. Part of the obligation is to kind of protect the institution. There's operational risk, there's fraud risk, there's market risk, there's reputational risk, right? You don't want to be caught in the middle of this headline every time because you didn't kind of do platinum standard diligence, regardless of what the SEC does, right? Independent of the commission, the CFTC, any other regulators, compliance is very much the order of the day. It's one of the huge takeaways from all of this, is that that's not really lip speak. I mean, I speak to clients all the time about this. The culture of compliance needs to be on par with the compliance, with the business of the entity. Because if it's not, the short-term risk or the opportunistic grab for money ends up where you pay a huge premium on the other side, and it's just not worth it from a business standpoint. It's bad business if you're not engaged in the compliance. And, I spend a lot of time with CCOs and GCs and in-house lawyers talking about this stuff because it's a way to protect them proactively before the oil spills. So I've kind of covered a little bit about the tone at the top being one of the takeaways here. I do believe that institutions are far more in tune with this type of discussion than they were when the Madoff fraud was kind of at its zenith. I think there's a lot more premium put on analytics by risk management officers. I think there's more of an investment in compliance that's emerged post-Madoff. The whistleblowing item, which I'm going to cover in a little bit more detail, is probably the most significant, permanent, here-to-stay takeaway from Madoff. And we'll talk a little bit about that. And more importantly, just kind of as a general matter, there is a more heightened awareness of kind of the issues of the day. There's a much more sensitized marketplace when it comes to data privacy, to security of customer information, and other things that weren't kind of part of the Madoff world, but have been kind of a byproduct of what I call some of the good that's occurred within the financial industry and within the securities markets. So the whistleblower part is super important. In one of the handouts, we actually went out with an executive alert today about this subject. Digital Realty was a really important case that found that folks who want the protection of whistleblower under the Dodd-Frank Act, which is, kind of the post-Madoff, post-Lehman, post-subprime, post-subprime collapse congressional response, is the whistleblower is required to go right to the SEC and report. You do not get the protections of Dodd-Frank if you don't report to the commission. This is a huge issue. It was talked about at the securities conference out in Phoenix by lots of the panelists. The corporate America was very aggressive in advocating this position legally. And now that it's here, it definitely kind of smacks of be careful what you wish for, because you now have created a huge incentive for your employees to run to the SEC as opposed to trying to manage potential malfeasance or potential fraud or a potential public relations crisis in-house. You lose control of the narrative by creating a culture and a case law that suggests that people should go looking to get rewarded and to be protected outside of their own company. So it's a little early to kind of assess the impact of digital realty, but my sense is that some folks are going to regret that this is the way it was advocated. The SEC is super committed to the whistleblowing program, regardless of their level of activity on enforcement matters. This program is viewed as a huge success. They've awarded over $325 million since inception, 60 individual awards. They look at thousands of tips as part of their enforcement obligations. And so this is viewed as part of their culture, regardless of what the political winds are at any given time. I also look at this from the perspective of Madoff and kind of say that this is an extraordinary what if. If the Dodd-Frank whistleblower protections had been in existence in '92, it's quite possible that we wouldn't be talking today, that billions of dollars might have been preserved, that the fraud might have been revealed a whole lot earlier than it was. That's one perspective. I understand the other side, that there's a lot of inherent problems in incentivizing people to quote unquote rat out, and that's one perspective. I don't necessarily subscribe to that jargon, but I understand the kind of competing tensions. But if there was a whistleblower congressional mandate back in the 90s, this might have been a significantly different discussion vis-a-vis Madoff. As I said, there's been to date over $350 million actually in terms of awards. In March of 19, there was another $50 million that were awarded to 2 different whistleblowers. The biggest part of the whistleblowing provision is that the SEC and others have done a pretty extraordinary job in maintaining the most important element of it, which is the confidentiality of whistleblowers. The program would not work if the specifics of any particular case were revealed or the identity was revealed, because the perception of the program is as important as the program itself. If people did not feel that their confidentiality would be protected, the program would be far less utilized. So there has, of course, been a lot of bad that comes with the Madoff legacy here. The biggest one is that there's been zero evidence, empirically, anecdotally, or otherwise, that there has been any chilling or deterrent effect, notwithstanding the historic recovery that has occurred in Madoff. Financial fraud is alive and well, and it is thriving in both Ponzi scheme, in both Ponzi scheme and non-Ponzi scheme contexts. There is no suggestion whatsoever that there's been even a modicum of a slowdown, and in fact, most evidence is to the contrary. Depending on one's point of view, the part of that is that nobody ever really gets prosecuted criminally in these cases. For those of us who represent banks and third parties who are targets, that's a good thing. For victims, they view it as, how do people make hundreds of millions of dollars facilitating Madoff's Ponzi scheme and nobody gets indicted? And the reality is that we see in the last 10 years since Madoff, literally trillions of dollars in commercial settlements, either in the form of regulatory enforcement fines or disgorgement, or settlements with class actions or opt-out litigants, but virtually no one has been indicted. Even in Madoff, the only people who were indicted were the truest of the insiders, in terms of the computer programmers and some of the people who helped manufacture false statements, but a very, very small universe. And this is going to be debated till the end of time as to whether or not you're going to see folks trying to pursue beyond a reasonable doubt type prosecutions. As I said today, Goldman Sachs is now facing at least a public swell regarding their involvement in the Malaysian fraud, where criminal prosecution is being kind of bandied about. It was all over the internet today. There were about 10 million articles about it while we were gathering this afternoon. The marketplace returning to super positive, everyone's doing well, as we highlighted earlier on, certainly affords fraud a great deal of cover. And so we expect when the market eventually takes a dip that you'll see a lot more fraud being revealed. But while it's kind of things are going well, not a lot of people are pressing to find fraud, and they kind of rationalize potential red flags or suspicions, as kind of nothing to be alarmed about, nothing to see here, that kind of thing. The Madoff case ultimately had, as everyone can imagine, an extraordinary human impact here. It's easy to talk lawyerly and regulatory and enforcement and kind of debate what the future is for some of the folks here. But people just got absolutely destroyed here, and it's not hyperbole. I've seen hundreds of the cases up close where people lost their life savings, where retired folks had to go back to work to be able to afford rent. And those were just individual small investors. Hundreds of millions of dollars was lost on behalf of feeder fund investors around the world, pension funds, institutions, charities, celebrities. It was one for the ages. It's really unprecedented, and the human toll here was pretty compelling and affecting. As I said earlier, the 65 billion was the fake statement number. 18 billion and change was the real number, and part of that number not being certain was what we had talked about a little earlier, is one of the feeder funds not contributing by kind of staying out of the United States jurisdiction. And so that had an effect on the way the quote-unquote denominator here was calculated in terms of the actual principal that was lost. Bernie Madoff serves as kind of the poster child for the debate about regulation and deregulation. Steve Fishman, who did a really cool podcast on Ponzi Supernova, debated this issue pretty significantly about how much regulation is enough. When Bernie was operating, enforcement regulation was really focused at various points in time on accounting liability in the Enron and WorldCom world. and was also heavily focused at various points on insider trading type stuff. And so this was not really the focus. And again, a lesser regulatory climate allows fraud and Ponzi schemes especially kind of to operate unchecked. Of course, right now, under the current administration, there is a pretty, aggressive deregulatory push. Dodd-Frank has already been chipped away at on some significant matters. It's a political debate, but it has real consequences in terms of financial fraud. The impact on the industry, I can't stress this enough. This is probably the biggest takeaway. It's the one that I work with clients on all the time, is that compliance, compliance, compliance. It is something that it's kind of an ounce of prevention up front, saves you zillion dollars worth of pain on the back end. You can use a lot of different metaphors to make this point, but there is one thread that you see that starts in Madoff, and it's across all of these Ponzi schemes and the Malaysian case I referenced. It's that there's a lot of competition within an organization that the lawyers and compliance people have to kind of referee. The people who are the rank and file, they have a lot of pressure on them to deliver business, to deliver sales, to deliver revenue, to deliver products that are going to make money for the entity, right? They're not really thinking about the entity at a reputational level. They're thinking about it at a bonus level, at an advancement level, at a how do I prove my bona fides to my boss so that I make a little extra money at Christmas and maybe I get a raise, right? The people who are in the high net worth area who deal with like super uber rich clients have a much different view, right? They are much more sensitized to those relationships and do not want to expose them to overreaching or to great risk. The lawyers and the diligence people at an entity, right, are caught in the middle, right? And we saw this in Madoff. Within the same entity, there were people talking about the fact that Madoff was running a Ponzi scheme. There were people at the entity talking about the fact that they wanted to do infinity in terms of leveraging Madoff's fictional performance. Same company, right? One group of people wants to do more and more and more and more Madoff. One group of people say, stay the hell away, the guy's full of it, right? And that sort of tension requires compliance officers, in-house lawyers, associate general counsel to work with outside counsel to get underneath that. Coming down on the side of we're going to take opportunistic risk at a rank and file level often causes hundreds of millions of dollars in settlements sometime down the road, and it's usually not worth the upside. And so the takeaway that we see in all of these financial frauds is what is going to be the role of compliance officers, a job, by the way, I truly admire, because those people now are actually personally in harm's way based on the way the kind of compliance world has evolved and the in-house world has evolved for GCs. It's an unbelievably sensitive and scary role to play at a company because you are taking individual responsibility for the company's numbers and for the decisions that get made that you're rarely, if ever, privy to at the first instance. So it's a huge takeaway from the Madoff case as to what I consider to be a need to always be erring in favor of platinum standard due diligence and platinum standard compliance, which has not always been the case. The bronze standard doesn't get you home anymore with the regulators or with the class action bar. In addition, there's been a increased scrutiny by regulators. As I said, the SEC, they took a pretty big beating here after the fact, and so that has had kind of a domino effect across the regulatory world. SEC, FINRA, Attorney Generals, Department of Justice, they are way more in tune to financial fraud and Ponzi schemes as a general matter. They're also more equipped. The regulatory agencies have invested a ton of money in data analytics and hiring far more senior type analysts than existed at the time of the Madoff fraud. So they are a lot more armed and they're a lot more ready for bear. And in fact, the kind of short-term consequence of the Madoff case was that the relationship between the industry and the regulators became extraordinarily antagonistic, even on the most simple of examinations. It was a lot more chilling and it was much more complicated to go through kind of a routine inspection or a routine examination. Ultimately, there are some hard truths here that come out, which is that, and it's again, as an outside lawyer who's kind of obsessed with protecting the client, you cannot rely on the regulators to do the work for you. The reality is that SEC and Congress and FINRA and the criminal agencies and the DOJ are only going to be able to protect investors and only going to be able to protect you all who may be defendants in investor actions one day so much. There is a lot of premium put on kind of your own self preservation and being proactive, not allowing yourself to kind of proverbially stick your head in the sand, so to speak. My friend Jim Mintz, who's an investigator at the Mintz Group, who was on that Ponzi Nova podcast I mentioned a while ago, he puts it pretty starkly, but it's actually true. Investors live in a savage world, a place where nothing protects you except yourself. There's no cavalry coming over the hill. And that comment applies not just to investors, but it applies to the people who are in the investment world, whether it's a bank providing leverage, a broker-dealer executing trades, an accountant doing audits for firms. There is a need to kind of be your own boss in all of this stuff and not kind of rely on third parties. It's a weak defense, like that you relied on the SEC or you relied on the regulators. It doesn't carry the day when things go bad and you're now negotiating settlements. Couple anecdotes before I wrap up is one, just kind of a lighthearted one, a little out of school, but we'll treat it as under the ambit of privilege. When I interviewed Madoff in prison, one of the questions that was asked of him was, did you bribe anybody to help you facilitate the scheme? This was at the end of a really long day, and kind of give you a visual of it. First of all, I mean, for those who have never actually visited a prison, medium security prison, no joke. He was in there with, real bad people and, killers and drug dealers. And this was not country club prison for sure. And when those metal doors slam behind you, even though you know you're leaving, still pretty scary, I won't lie. I've been to prison a bunch of time representing folks, but this was no joke. But in any event, we met Madoff in like a cafeteria where the inmates all went and would use the vending machine or get a sandwich or a soda or whatever. And we were sitting on these like really tiny plastic chairs that you sit in when you're in grade school, right? So you got to picture this frame and like one of these tiny little chairs. I was like, this is insane, right? And so while we're interviewing him, it was kind of the end of, I think it was the first day or the second day. We had like 4 hours with him, and we did it over 4 different days. And one of the questions at the end of the day, as I said, was, did you bribe anybody? And he said, no. And we like, really? Like, we were a little dubious about that. And he was like, yeah, I know it's going to sound funny coming from me, but it would have been illegal. Right? And we, of course, after a super long day of kind of banging away at a bunch of things that we wanted to cover, we just burst out laughing. Like, we couldn't help it. It was really funny. His point was well taken. We understood is that he was trying to keep the fraud super contained, and the more people you invite into the inner circle, the more likely it is that you'll get caught. So he actually didn't do anything that, we might think of as violating anti-money laundering laws or, bribing bank officials or doing anything like that, because he simply didn't want anyone else to know. If I ever wrote a book, it would be The Exit Strategy, because his exit strategy was death. He had no exit strategy. There was no kind of like, I'm going to run away, I'm going to Switzerland, there was none of that. He just thought he was going to run a Ponzi scheme until he died, and then it was going to be there. So kind of fascinating stuff. So I thought it would be kind of funny to look up how many fraudsters shared my name and to see if I was related to any of them. So Bernie Kornfeld was a famous Ponzi scheme artist in the mid-'70s. At the time of this, I was 8, fortunately not my guy. Fern and Barry Kornfeld are alleged to have been involved in a Ponzi scheme more recently as external sales agents in a fraud that kind of emanates out of Florida, but had some far-reaching tentacles. The good news is, no relation. Fern Kornfeld, who's the name of the woman in the prior slide, incredibly is also the name of my mother. And my dog, Chloe, is not in a Ponzi scheme. And that is me last year at the World Series of Poker at the main event. before I sat for a few days, and fortunately none of the Kornfeld Ponzi scheme artists are in my family tree, so good news there. It would suck if I was part of a Ponzi scheme family. So with that, we've covered a lot of ground, and would be happy to take any questions or have any discussion about. Yes?
Can you add some color of how big the inner circle was with Bernie, or who was part of that inner circle?
Yeah, I mean, so the true inner circle are the people who ultimately were charged and who were convicted. There was about half a dozen folks who were programmers who went to jail. One of them died, his Lieutenant Frank, who kind of became a cooperating witness with the government. He died prior to the trial. He had lung cancer. His brother Peter went to jail for 10 years for, as serving in the de facto role of chief compliance officer for the market-making business. He didn't actually plead the Ponzi scheme on the investment management side of the business. There were a bunch of programmers. His accountant, which, if you read any of the pleadings in Madoff, they're pretty repetitive on this point. His accountant was a strip mall accountant. He had like 3 employees and, should not have been the accountant for what purported to be an $18 billion asset management global investment company. It was the kind of guy you go to if you, make 60 grand in income and you need your taxes done. And he went to jail as well. David Freelanding, if I'm pronouncing it right, I'm butchering that last name. But he was in the inner circle as well. There's a debate amongst a lot of people who worked on the case as to who knew what within his family and who knew what at the feeder fund level. And who knew what at certain banking levels. But his true inner circle were the people who were his employees, who had been there forever, who were devoutly loyal to him. And they're all kind of well showcased in the 2 movies that were done about this. The Dreyfus movie is a little more realistic about the fraud and what happened and who the players were. The movie with De Niro and Michelle Pfeiffer is told from the point of view of the author, Erin, whose last name I can't pronounce at all, who wrote the kind of the quintessential Madoff book. She had a very specific point of view. It was about kind of her view about the sons, and there is a little bit of Shakespearean tragedy in all of this. Both sons passed away. One killed himself on the 2-year anniversary, and the other died of recurring leukemia. But her perspective was a much more sociological look at the family. And for those of us who worked on the case, we liked the first movie better because it was a little bit more jazz about the fraud itself and some of the players and some of the contributors. So it was a small inner circle. It was a little, the short answer, which I probably should have led with. Sorry.
Did the inner circle guys get away with any money that they never found?
No. Most of that, they didn't make as much as you think they should have based on the fact that they were running a 30-year Ponzi scheme with Madoff. The one thing that I can say is that it was pretty miraculous is that a lot of the money was easy to trace because there were tons of records that the trustee found upon coming to the Ponzi. And that leads me back to kind of a point I made earlier in the day, which is that, you're in year 11 right now. And a lot of people are kind of like, the Madoff thing, is it still going on? Why is it still going on? Well, the trustee is appointed by Congress and the court, and there's $5 billion that hasn't been recovered just in real principle, not including the trustee's attempt to get kind of a general estate going to kind of try and reimburse people for lost income. And ultimately, the first few years of the recovery effort are spent unraveling it. There's no GPS when you come on the crime scene. That's my partner said that once. He didn't say it exactly that way, but there's no instructions. There's no manual. You get on a crime scene like that and you're starting from nowhere. So you're working with forensic accountants and you're working with consultants and, you're working with investigators and, it takes a couple of years to trace where all the money is and to process the information. And that, of course, is with the clock running. The statute of limitations to bring initial transferee actions is 2 years. And so we were filing these actions to beat the statute the first 2 years we were on the job. We filed 1,000 cases. I hate to admit it, but I read all of them. I was one of a handful of lawyers who tried to make sure that we were being consistent in the arguments we were advancing, and the complaints, weren't competing with one another on advocacy. defense lawyers, and, if I'm on the defense side, I would be doing this too. I'd be looking for places where the trustee was trying to have it both ways. And so there was a huge premium put on that while we were doing these initial transfer cases. So it's kind of the Wild West when you come upon a scheme of this magnitude and this kind of duration and scope and all that kind of stuff. Yeah.
Somebody alluded to this, but what are your thoughts about FINRA's role? Mentioned the SEC a number of times, but what about FINRA?
In connection with Madoff, pretty much took a back seat. This was viewed at federal level in parallel with the Department of Justice, who was significantly involved. The trustee, Irving, at one point was asked to serve in a dual role, to be the trustee for the monies that the Department of Justice was forfeiting as part of this. So, for example, Jeffrey Pickauer, who passed away early on, his widow reached a settlement with the trustee and the Department of Justice. And Irving was not able to serve as the trustee for the Department of Justice's fund because it would have created inherent conflicts between classes of investors. Irving's obligation was to return money to customers, and that was why the SEC was so directly involved and SIPC was directly involved. FINRA had very little involvement in this after the fact, for sure.
And yeah, like during exams too, and covering any thoughts about its role. They must have examined the firm a number of times over the years.
Yeah, they did. And the big one, the one where they really kind of missed it was in '05, because at that point they were getting some leads, and there was a lot of internal communication at the enforcement level that something wasn't right, that they just didn't get it. There were super smart funds that could not kind of, as we refer to it, reverse engineer this strategy. And people were talking to the SEC, but what ultimately kind of drove that was a guy named Harry Markopoulos, who people might be familiar with. He couldn't figure out the strategy. And he wrote like these manifestos to the SEC saying, the world's market maker, former chairman of NASDAQ is running a Ponzi scheme. He literally wrote this and wrote like this 19-page single-spaced manifesto. And the problem is that he kind of was perceived, for better or for worse, as a bit of a crackpot. He was viewed as someone who had an axe to grind, like that he wasn't doing well in the market, so he was trying to take a shot at Madoff. But they missed a lot of the red flags that he had identified in, '04 and '05, as did a lot of people in the industry. He didn't just go to the SEC. He was talking to folks at banks and other folks too. Kind of ties back to the idea of how whistleblowers might be perceived differently, in light of Dodd-Frank after the fact. But yeah, the SEC missed a bunch of opportunities along the way that are pretty well chronicled. And, I'm not saying anything revolutionary. They said it themselves in their own OIG report that came out after the fraud. Any other questions or anything about the interview or anything else we can give you in terms of substance? Otherwise, oh yeah, please. Small fraction. So yeah, Madoff, it's funny, for someone who ran like this global Ponzi scheme, he didn't live like insanely large. Like he wasn't jet setting around the world, and like he had a lot of the trappings of someone who ran a hedge fund and, made a bunch of money. He had a bunch of houses and he had a boat and he had some kind of weird assets and, some unique artwork, but, it wasn't like for someone running purportedly $65 billion, it wasn't like crazy obscene. And it was not the largest source of recovery by any stretch. It was a few $100 million at the end of the day. It was, most of the money came from, people who received it, or who invested where they settled with the trustee. Yes?
You asked him why this incredible Ponzi scheme frauded people out of billions of dollars and in jail for the rest of his life. What was the driver for him talking?
It's a great question. So I could tell, first I'll flip the question and say the driver for me, as someone who got to the fraud about 8 months in. So the fraud was announced in December of '08 to the world, and I joined Baker in September of '09. So a lot of the early kind of investigative and forensic work had been done, and kind of dealing with the family had been done. His driver to talk to us is actually multifaceted, right? One, I think in his own mind, right, and this is a little speculation, but I think I'm right, is that he thought that by talking to us, it might impact the way we evaluated the claims against his wife and the claims potentially against his kids, although much more his wife. He had a lot of remorse about Ruth and that relationship. That was genuine, I felt. Not much else, though. He was pretty sociopathic in lots of ways. So I think that was one of his reasons to talk with us. Second, I mean, not to be like stupid about it, but I think it was a break in his day, right? He got to talk to super smart people who were going to indulge him and let him wax philosophic about, his time as the head of NASDAQ. And, he would talk about the strategy, though he actually ran it, right, as if he was actually trading. And from time to time, we'd have to stop him and say, yeah, none of that happened. He goes, oh, I know, could have, though, right? So I think he wanted the respite. He wanted to be able to kind of talk about it, and share part of his day that wasn't kind of mopping floors or working in the library or, talking to criminals. Like, I think he enjoyed the banter of it. It's also like we were very deferential because we wanted to get information. So we were, respectful. We weren't judgmental. We were just kind of having a conversation the way we are because we needed information. And again, important to note, we went there pretty well armed, knowing what had happened. So it's not like we needed him to kind of give us a roadmap. It was much more to kind of test some theories and there were some gaps that we wanted to kind of probe at. But by the time we got to Madoff, we had a really good understanding of what was going on. And there were just a bunch of things we wanted to know. And we also wanted to know who he kind of viewed as good and who he kind of viewed as bad. And he definitely gave us that. Like, we knew when he was looking to protect somebody, and we knew when he was happy to throw somebody under the bus. I mean, he made a lot of people a lot of money. So he was defiant about a lot of it. Like, there are people in the Madoff Ponzi scheme who made tens, if not hundreds of millions of dollars off of his fraud. And look, I don't say this with admiration. I just say it as a fact. Like, that guy went to work every day. Running a $18 billion fraud didn't happen by accident. Like, that was his job. He worked 12 hours a day at the fraud, right? So he was like talking to clients, he's talking to banks, he's, keeping track of that many lies. Imagine if you've like lied to two people and you're trying to remember like what you said to one person and what you said to the other. He did it with thousands of people and had to have like perfect recall about this stuff. And he had to network because he had to get new money, right? He was always looking for money. So, and that whole strategy of how he extracted money, the movies do a pretty good job at that. Like, he told stories that were like that. Where he made people beg to get into the fund. So that was his full-time job. So he spent a lot of time working it. Pretty crazy. He's no mastermind. I mean, obviously, if you run a fraud that long, you can't deny the fact that he's smart. But it was a perfect storm. There was lots of contributing factors that allowed that fraud to perpetuate itself for a really long time. He was a bad trader who went rogue, basically. Yeah. Sure, he was super charming. Like, I mean, you could see how people would like him, I mean, if I met him and not in prison, just met him in a bar and had a beer with him, he's a likable guy. Like, he can be charming. I think, look, it started off as a regional kind of affinity fraud. There was a bunch of big money guys who started this fraud. So there was Pickauer, there was a guy named Stanley Chase, there was a guy named Norman Levy, and I'm blanking on the fourth guy, and I should know this by rote at this point, but I don't know why I have a mental block on the fourth one. They were kind of insiders at the early stages of the fraud, and so at the end of the day, he had a running start, right? He had lost a bunch of money as a trader, and instead of owning up and just taking the losses, he decided he was going to borrow money from his father-in-law, and he was going to just run a Ponzi scheme. It's literally how it happened. Like, he lost money the first time, went to his father-in-law, covered the losses because he was embarrassed. The second time, he didn't go to his father-in-law. He just started raising new money to replace the old money. How did he do it? When he was small, it was kind of interpersonal, right? It was one-to-one. When he got big, he became so big that he could make it exclusive, meaning he was doing you a favor
to let you in. And that scene in one of the movies about where the guy's kind of bidding against himself, where he says 200 million, 300 million, 400 million, that was true. That was how he went about it, like with these foreign feeder funds especially, where he just got this massive infusion of capital. And then the other thing he did was, he was pretty ominous in his threats about what would happen if you pulled your money, right? So he was delivering paper returns, but he put the fear of God in the people who were investing as to what would happen if they yanked their money. And so, a lot of the perpetuation of the fraud is that the money sat there, and he's rolling in all this foreign money, and the outflows are being contained. It's getting a lot of in money, and not a lot of money is going out. The reason the fraud craters in 07 and 08 is because everybody in the world needed cash. Cash was king. Nobody wanted to leave their money anywhere. They didn't care that Madoff was saying he was doing, profitable type investment. So it was a combination of things. Like it was interpersonal, it was strategic, depended on who his audience was. But he was pretty charming. And he had some gravitas, right? He was the former head of NASDAQ, and no one would have a natural reason to suspect him. It was only once you started kind of kicking the tires, there were a million red flags. But he started at a retail level, as Matt was talking about earlier. Right? Retail investors aren't kind of prone to the red flag due diligence type analysis that those of us who live and breathe in this industry are. So he got a running start taking advantage of people.